Yeah, hi everyone. I'm Jessica Fajfar, and I work with Heather Rafter at Rafter Marsh, and I also run a pro bono law clinic at the University of San Francisco.
Hi, I'm Mark Owen. I'm a partner at Taylor Wessing in London. We're an international tech plus IP firm, and actually Jamila used to be one of our corporate lawyers, and we work with ROLI, and we act for a lot of, I guess, tech companies trying to protect their IP.
Hi, and my name's Murden. I work at ROLI in the sales and marketing team, but formerly worked at numerous tech companies, both large and small. So together we're going to be working on the topics for today. So a couple of things that we want to go through in our session is what to consider when choosing a brand, how to grow your brand, and then working with whether to work with artists and celebrity influencers and endorsers. So, sorry.
I was going to ask, what should we consider when choosing the brand?
Indeed. So a couple of things, and this might be straightforward for some people, but it's actually a common mistake that a lot of people make, either when they come up with an idea first or a company first, is to distinguish between the company, the product, and the brand. So companies make products and services, but it's the consumers that actually make a brand. Brands really offer emotion. Products can be copied, but actually brands can't be copied as easily. So we're going to go through a few bits today. So one of the things that's quite important to distinguish when you're coming up with an idea, and whether it's a product idea or whether it's a company idea, is actually what do you stand for? And I've worked with many products and companies in the past, and first of all is coming up with what's your objective? What's the problem that you're trying to solve? And is it something that consumers are actually willing to pay for? And this is very, very important to distinguish. So, for example, I've worked at multiple companies before, but when I was at TomTom, the problem that we were trying to solve is that people love to go running, but they don't want to run with their mobile phone. So coming up with, and then the reasons why all of those pain points is that because I don't want to get lost, I want to measure my heart rate, there's many things. So then coming up with the product, and then which part of that product actually makes it unique, and then therefore a product that people are willing to pay for. So one of them was a sports watch, and it measures your heart rate on your wrist, and then within that there's the technology that you can then be patented to make it unique, and then therefore a reason for people to buy the product.
Yeah, and just we'll touch on this later, but just to let you know the difference between the patent and the trademark. The trademark is really your brand, so it designates the source. So when you see the word, the logo, the design, you're going to think of the company, versus a patent, which is protecting the useful aspects of the product, like Laura was just referring to.
And then it's just about finding that something yourself that you can actually have that point of difference.
Exactly.
Okay, so I've come up with an idea.
So when you're choosing the brand, there tends to be this dynamic between marketing people particularly really like things which really describe what the product is, what it does. And I think you end up with a continuum, if you like, between very, very descriptive kind of marks, does what it says in the tin, that's what the acronym at the bottom is for, against things which, if you saw the word, you wouldn't have any idea what it was, what the product was, what the company was. And this slide's really just with some simple examples to illustrate that continuum, which is you get these marks, which, at the time, Google, okay, it's similar to a maths term, Google, but no one knew what Google meant when it was first being used. Apple doesn't make any sense in the context of computers. Two, on the other end, double mint for chewing gum, and there's been lots of trademark cases about whether you can have a trademark for double mint. Last minute, very, very descriptive. It took them a long time to really establish that as protection. And in choosing a brand, you really want to think about, well, what is it you're trying to do? Is it important from a marketing point of view to have something that's instantly recognizable? Are you going to have the marketing budget to build up something which over time people think, oh yeah, I know what Spotify is? Or do you want to have something in between, which is sort of suggestive, but also not completely obvious, a Microsoft or a Twitter or something like that, which has a sense of what it's about, but doesn't really exactly say what it does on the tin. And this is important from a legal point of view, but I think you should never let the law be the tail that's wagging the dog on this. From a legal point of view, it's a lot easier to protect those distinctive marks, those things you don't really know what they are. Think of something like TripAdvisor. TripAdvisor is a very descriptive word, really, but you always think of it with that logo. So sometimes you add a logo element or something like that to make it a bit more protective.
And when you think of a trademark, you usually think of the word or the logo, but trademarks can be actually quite broader than that. So thinking about how broad you want to go, for example, sounds can be trademarked. So when you hear a particular sound, you automatically think of that company, for example.
Oh, sorry. And then
so I think we all recognize these sounds, and immediately upon hearing them, you think of the company. And also not only sounds, but smells. We have smells, we have colors. We'll get into this more a little bit later, but also designs. So interestingly enough, Apple has actually trademarked the design of its store, how it looks. So if you were to walk into another store that had this look and feel, you might think, oh, this reminds me of Apple. So Apple actually protected this also protected its adapter. When you see these adapters, you think of Apple. Fender has protected the guitar head. So when you see that specific design, you think of Fender. And so other guitar companies cannot use this exact design. And then you have the Lego blocks. So when you see these blocks, you automatically think of Lego.
And sorry, just to jump in there, there's also an interesting development now, isn't there, around VR and AR about feel marks. That what, if you've got a haptic kind of experience, what that feels like and whether you can protect that in some way as some kind of brand. And there's a lot of research going on to how you do that. But I think you'll see marks right across the board soon being protected in terms of, when you're in a particular environment, that's the Apple environment or whatever.
And I think the key thing on all of this is really finding something within your product or service that can be unique to you, and then therefore something that you can then protect yourselves against. So real life example, I work for a company with my brother creating an augmented reality app. Augmented reality in itself cannot be patented because that's, it's a platform that can be available to everyone. But then there's certain features within that we can protect ourselves against to be able to give us a point of difference. So I think here there can, not always, but trying to find something that gives you the point of difference. Okay, so you've got your fantastic idea for a brand, and then you want to grow your brand. And there are many things that can be considered, and we can't touch on everything today, but I think there are a few important things. In terms of what you stand for, so there are many companies that are specific to one type of thing, and then they have a filter. So whether it's joy or simplicity, and then in terms of growing the product line, then looking to see whether you stick within that brand filter, so that then you can look to grow your brand either by having multiple products or taking one product into more markets. And then also looking at then what activities you can do to grow your brand. So there could be that you can partner with other brands that have similar target audiences. So for example, if you're a really small company and you know that you don't have the budgets to be able to grow yourself with the budgets that you have, then partnering up with someone else that already has an audience that you can then link and relate to. And you can be really, really creative and also taking quite calculated risks. So we were talking about this before. Sometimes you want to strike while the iron's hot if you see something in the media and do like a viral tweet or whatever because you want to be able to... Some brilliant examples last week with the Elton John Christmas advert. Now, of course, if you had to wait to get proper approval, it would take too long. So just understanding the risks and basically having legal as your friends, because there are many things that you can actually do that are not going to cause too much difficulties, I say, as the legal team look at me. But just take it, as long as you understand the risks, and sometimes you really have to be creative because ultimately we want to be able to grow our brands and, get ourselves out there. So then, Jessica, what should I do to look at whether I should be protecting myself?
Yeah, so once you have a brand, you may end up having to enforce it. So you really have to think about, how and when do you enforce? And the how could be considering whether you want to be really aggressive and nasty, which a lot of times you get, a cease and desist letter, and it could be really have a bunch of legalese and just be really nasty. And that could really backfire. There's been instances where the other company will post that cease and desist on social media, and then you end up getting a whole bunch of backlash from your consumers, like, why are you being such a bully? And so really work with your lawyer in terms of, how you want to go about enforcing. And then you could be more playful. You could be a little bit nice while still enforcing your mark. So an example was Netflix. They have a show called Stranger Things, and there is a Stranger Things pop-up bar, which they didn't have a license with this pop-up bar. So instead of being really nasty, they sent sort of a playful cease and desist letter using sort of the characters of the Stranger Things, and in the end saying, look, you could use this pop-up bar for a few weeks, but please reach out to us in the future if you want to further license. And that actually ended up with positive feedback. And then...
Sorry, just to say on that, the
Yeah.
trouble with that is now all clients want you to write funny cease and desist. Can be very challenging.
And then you want to think of when to enforce. So really what you're trying to enforce against is confusion in the marketplace. So you don't want people to be confused whether you're affiliated with this other brand or you sponsored this other brand. So actually a few days ago, Monster Energy won a lawsuit against Monster Mobile, and Monster Mobile actually sells automotive parts. And they're like, well, consumers don't drink wrenches. Why would they be confused as to whether, we were affiliated with Monster? But the court held that, Monster is such a famous brand, and they actually sponsor automotive events. And so there's sort of an affiliation between the goods and services, and they use sort of the exact same green. So that Monster Energy ended up winning that versus Dr. Dre versus the real Dr. Dre. The court held that, consumers are really not likely to think that Dr. Dre licensed his mark to a gynecologist. And the first Dr. Dre, he lost on that one. So it's like really considering, like, what are you concerned about?
And there's a good example, isn't there, in this field actually, where Apple, when it first brought out products which work with music, Apple Computer, came up against the Beatles, whose company is Apple Corp, and they had lots of trademarks for Apple for music related. And so companies which were distant, as these were, as technology evolved, they came together, and there was litigation over many years, over a series of agreements between them as they tried to define the world into two separate things, but the clear blue water, disappeared as things moved on.
Mm-hmm.
Okay, so we all know how important reviews are to selling our products and services. Mark, if there's a bad review, can I get it taken down?
It's going to depend what it is and where it's happening. So, and Jessica will talk to this as well, that there's a bit of a difference in approach between countries such as the UK, where we still have relatively strong defamation laws, things like that, where if you really are saying something very untruthful and making people think worse about something for no good reason, then you've got a chance of saying, actually, that's defamatory, and at the very least I can get the platform, take it down, and possibly I might sue them, versus the US, where there's a stronger First Amendment right. Mm-hmm. But reviews, I think, are a minefield. People unwittingly put up reviews of their own product, which are favourable, to say, there's this product I've been reviewed very well somewhere, but if it's not actually the same product or the same criteria, then actually that's misleading, and so you get into advertising regulatory issues.
But then
I want to mention the US approach.
Yeah, in the US it's quite hard. Even if a review is defamatory, we have a law, which is quite weird, that says the service provider does not have to take it down, even if you request that it's taken down. So that's a bit of a shame, but I think Laura could tell us some more practical approaches.
Yeah, so I think the key, well, in my experience, is more about how you respond to the reviews. So actually engaging with the customers, and it could be that there's one specific issue. So by then replying to the reviews from the company, actually responding, either answering their questions or just responding. Occasionally, they can then change their reviews. Obviously, they might not. But I think it's down to how you engage with the consumers, and then hopefully the more positive reviews you have, the more negative ones can go further down the page. But unfortunately, in this digital age, there's no way of avoiding it, but definitely responding can help. Which leads us nicely into promoting our brands.
Yeah, so advertising obviously is absolutely crucial, and using the brand in a particular way. There are rules in each country, as you may expect. Some are stronger than others about having a message which is honest, truthful, and doesn't sort of take unfair advantage of people. And so in the UK, for example, there's a self-regulatory body called the ASA, Advertising Standards Authority, that has a series of voluntary rules. And I say they're voluntary, but actually if you don't follow those rules, you'll get censored, and then you won't be able to place your ad in lots of the places where you choose to place it. If you're going to use your brand and ad, then you're more likely to come up against people who say, well, actually, what you're doing with your brand infringes, encroaches into my part of the world. So it's worth thinking about the context and how it's going to be seen. I mean, your example of the John Lewis ads, if you take the mick out of the John Lewis ads, depending upon what you do, and if you're a real competitor, there's a chance at some point you're going to get sued for it. However, if you're in a different area, you're just using it for attention, it must be much less likely.
And then in terms of having claims within adverts?
Well, the claims, as I say, they need to be essentially honest and truthful, and you need to have the ability to sustain those claims if the regulator comes after you and says, well, actually, you say your product is better, faster, cheaper. What's the proof? And you need to have a file of material to show you haven't just made this claim just because you felt like it, but actually there's something you can rely on there. And you find that sometimes it's consumers that will complain, but usually the people who complain are your competitors, and they're going to be very, very vigilant for you overstepping the mark in terms of what your product can do, what you can't do. So I think you can say interesting things, you can take risks, but you need to have the ability to back it up. And then this is a slightly different topic, but obviously if you've developed a great brand, then there's only so much often you can do with it in terms of monetizing it, commercializing it, finding customers for it. So often you're going to need to expand the use through working with third parties. So whether it's business partners who say, well, we're going to put that product in our product and use your brand in that way, whether it's through in different contexts franchising, so basically, like a Subway kind of model, you set up these restaurants in as many places you want and you follow a playbook. All of these are versions of a sort of brand license. I guess the most important things about brand licenses are, and you can flex them lots of different ways, but keep in control. These are your trademarks. You don't want these people going off using these trademarks in ways you don't want, and in ways which actually may damage the image you're trying to put forward. The ability to pull the license back at some point, say, no, enough's enough, and/or I've got a better opportunity. I'm going to give notice on this first one, and I'm going to move to the next one. And having, and that the reference on their trademark guidelines is about how you use the brand. So it's very important to have some brand guidelines saying, these are the fonts you use, these are the colors, this is where you put it. You don't use it in a descriptive sense. So, you look at someone like Lego. They always talk about Lego bricks. You'll never see them say a Lego, and you'll never see. Well, Hoover got into a lot of trouble for it because Hoover has become this kind of genericized word, but good brand owners take a lot of time to control how their brand's used so it doesn't become the word for something. As soon as it becomes generic, you've lost your rights.
Mm-hmm. Which could be a whole other topic in itself.
Yep.
Okay, so given the industry that a lot of us are in, we often get asked the question in terms of should I consider using artists or celebrity influencers and endorsers, and then what do we need to consider? I think we haven't got a huge amount of time, but in terms of some kind of basic rules is, first of all, understanding exactly what do you want this person to do. So is it that you want them to be, so do you want to be seeding products to them to be using so that they can then create user-generated content for you? but that's not necessarily a formal contract. We're just gifting them a product and hoping that they will use it? Or do we actually want to be paying someone for specific tasks and services? And I think that's where working very closely with the legal team and actually having a formal contract so that you can say, right, this is what the brand is doing. So we are either giving you a product or asking you to create something, and this is what we expect back in return. And there's a couple of examples of where this is not.
Well, there's a good case at the moment going on. I think it's Snap. Is it Snap Spectacles or something like some product which a guy who I think had been photographed with the Kardashians, therefore he had a lot of followers, therefore had a contract to promote these things by, I think he had to make 4 tweets or 4 posts and wear them, and he didn't do any of those things, but he did get paid 45 grand up front with another 15 to come, and now they're suing him to get the money back. So I guess the lesson from that is try not to pay too much up front, know who you're working with, and make it very clear what they've got to do before you pay them.
Okay, so conscious that we've gone through quite quickly, but we've managed to save a few times for questions and...
Anyone have questions? Well, if you think of any questions, then the sort of Decoding Law team will be in the backspace room.
So I was just saying that if you can't think of any questions now, then later on the team will be in the backspace room later on.
May I ask a question?
Of course you can.
Can I say that someone uses my products? Am I allowed to list that?
That's a very good question. Ask the lawyers.
I think that, yeah, you
If you have their permission.
if it's truthful, I mean, you can't use their likeness to endorse your product. So that's the thing. In the U.S., we all have rights of publicity, and if someone uses your image or your likeness in order to promote their own products in a commercial manner, you actually have a right to some compensation. So I would say probably you should get permission before using their likeness.
Hi.
Hi.
Yeah, thank you. I came into this talk trying to get more information about the patenting part.
Yeah.
I've kind of learned that trademark is to brand as patent is to product, kind of, maybe. Yeah, but is there a way to find more information on the technical part of how to define a patent?
Yes.
If I were to write one myself, try to write one myself.
Yeah, so we're going to swap in some speakers, and we're going to go more into registrations, different forms of IP, and then patents. So if you would like to stay for a little bit longer, stay tuned for patents.
Yeah, so that's
Well, that is a beautiful segue. Thank you very much for that question. So could we all put our hands together for...
team. So now we get to go, right? Yep.
So if the IP team could come on stage.